So 25 states have joined together to push the Supreme Court to finally strike down assault weapon bans. So let's talk about this. But real quick before we jump into this video, if you think a ban on AR-15 rifles is unconstitutional, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has some of the best coffee out on the market, and also they are huge Second Amendment supporters. Jared's from Guns and Gadgets also is part of that company. So they do amazing things. They also often donate a lot of the money to two-way organizations. So if you're interested, use the links down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Also, want you to note that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, 25 states have joined together to push the Supreme Court to finally strike down assault weapon bans in a case that is currently up for their review. The case we're going to be talking about is Bianchi v. Frosh. This case is asking the United States Supreme Court to strike down Maryland's unconstitutional ban on so-called assault weapons. Now, 25 states, which include Arizona, West Virginia, Alabama, Alaska, Arkansas, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, New Hampshire, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, Virginia, and Wyoming have all joined together to file an amicus brief to the Supreme Court, arguing that this is a case and issue that the Supreme Court finally needs to take up and address. Now for some quick background on this case. The state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, or possession of semi-automatic centerfire rifles with detachable magazines and two offending features, like a folding stock, grenade launcher, or a flash suppressor. It also bans a semi-automatic centerfire rifle with a fixed magazine that can accept more than 10 rounds. The state also bans semi-automatic centerfire rifles that have an overall length of less than 29 inches. And to top it all off, the state also bans a specifically identified list of 45 named type of rifles. Now, Maryland does have some workarounds, like they have this heavy barreled rifle rule that is a workaround of this general ban. But in reality, there is still an assault weapon ban on the books, and it's likely only a matter of time before the state decides that they want to plug that hole as well, like we've seen in other states like California. California often has workarounds, but often what happens is the state legislator then says, well, this rifle in this configuration that was a workaround to our language, we're going to plug that hole, we're going to change our language, and now that rifle as well is banned. Now, this case arises out of a challenge to that Maryland ban. In this case, the plaintiffs argued that a prior decision by the Fourth Circuit in a case called Colby is incorrect. In that case, an en banc panel found that these rifles are outside the ambit of the Second Amendment because they are useful in military service. Therefore, the Fourth Circuit en banc panel upheld the state's ban. So the Fourth Circuit used a test which was never used in the Supreme Court case Heller, which is the landmark Second Amendment case that we have. Instead, they pretty much made up something on their own, and they used this weird military service analysis. This case here is up for Supreme Court review, challenging that ban in Maryland and also the Fourth Circuit's incorrect analysis. The question presented to the Supreme Court in this petition for a writ of certiorari is whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with a type of arm that are in common use for lawful purposes. Now, in support of this case, 25 states have joined together and filed an amicus brief arguing further that the Supreme Court needs to actually address this issue and hear this case. In their brief, the states argue this case presents the court with a unique chance to provide additional guidance to the lower courts about the scope of the individual right protected under the Second Amendment. 15 years after Heller, lower courts continue to refuse to recognize the full extent of that right. For example, they say, while some lower courts have correctly concluded that the Second Amendment protects the right to carry arms outside of the home, others have concluded that the Second Amendment does not confer such a right. Lower courts have also, inconsistent with Heller, upheld broad bans on constitutionally protected arms, so long as some arms of some type remain available for use. And many lower courts continue to utilize tiers of scrutiny with interest balancing tests to uphold nearly all firearms regulations. Therefore, they argue, this case is an ideal vehicle to provide clarity in each of these areas. So they're saying this is a perfect case with a lot of these kind of confusion issues and issues that pop up a lot in lower courts. And this is the perfect vehicle case to address a lot of those issues. Now, the first main argument that the states make in their brief is that the court needs to resolve the confusion in lower courts on the appropriate analysis when it comes to Second Amendment cases. They state the court should grant certiorari for one simple reason. The lower courts need help. In the almost 15 years since the court decided Heller, lower courts have construed it inconsistently and narrowly. And while the court has addressed at least one outrageous case, being the Catano state ban on stun guns, it has become increasingly clear that the lower courts require a firmer hand. Even these many years later, the lower courts do not appear to have any firm idea about who the Second Amendment protects, what the Second Amendment protects, where those protections exist, and to the extent that they do exist, why they exist. So essentially, the states are arguing here that lower courts are either dumb and don't understand what this right is, or they are blatantly ignoring the right, and the Supreme Court essentially just needs to slap them. The states then in their brief go on to give examples of various court decisions on various Second Amendment topics, and how these lower courts are all over the place on their decisions, and they're even all over the place on the type of analysis that they apply on likely same issues. So one state might address a so-called ban on assault weapons, another state or circuit will address the same issue, but they will come to completely different decisions and they will use completely different analysis. And here what they're arguing is because of this, it is time for the Supreme Court to finally correct that issue. The second main argument the states make in their brief is that the Fourth Circuit's novel military service standard is directly contrary to what the Supreme Court said in their Heller precedent. They state in their brief, instead of asking whether law-abiding citizens commonly use the item banned for lawful purposes, the Fourth Circuit has crafted a unique and unsupported standard. It fashions its new rule by misreading a single conditional statement made in dicta in Heller in response to a separate hypothetical argument. The court did not hold outright that states may ban the fully automatic M16, and it certainly did not suggest that states could ban its semi-automatic civilian cousin, the AR-15. Rather, Heller addressed an argument about the connection of the Second Amendment right to the prefatory clause if weapons that are most useful in military service may be banned. On its face, the Fourth Circuit's novel standard leads to absurd and confusing results. For instance, the Model 1911 .45 caliber pistol may be considered a weapon most useful in military service, given the military used it as its standard sidearm for nearly 75 years. Yet it is also one of the most popular civilian handguns today. So here the states are arguing something similar that I mentioned in a prior video on this case. The Fourth Circuit's analysis that they used would lead almost every common firearm to be banned, since many were created for the military for military use. Many have been used in the military, and even right now, many are still used in the military. So those are the two main arguments made by the states in support of why the Supreme Court needs to finally hear this issue and address this case. This is one of those cases I think will be really intriguing to the Supreme Court because it deals with a larger Second Amendment issue, i.e. a ban on so-called assault weapons or just a ban on the standard AR-15. And it also deals with a circuit's clearly incorrect analysis that needs to be corrected by the court. So I will definitely be keeping my eyes on this case, and I will let you guys know whenever we get more information. But again, this is a really interesting case, and it will have huge implications for other states and other kind of jurisdictions that like to implement these types of bans, like California, New York, New Jersey, other states as well. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I cannot thank you guys enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me reach more people than I could have ever thought. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station was built by Armed Scholars, and this nation will be maintained by Armed Scholars.